I'm here with Herbert Smith, Freehill's partner Patrick Gay, to discuss the final report of the Harper Review, which advocates sweeping reforms to competition law and policy. Patrick, what are the key recommendations of the Harper Review and how might they impact business?
At a high level, the panel considered reforms in respect of the competition law, reforms in respect of competition institutions, and reforms to competition policy. And that last element was really considering the rules and regulations surrounding certain industry sectors, including, for example, taxis, pharmacies, the human services sector. If those areas open up to competition, there will be significant opportunities for business. Of course, there will be winners and losers, and I expect there to be a highly politically charged debate before any of those reforms are actually implemented. Turning to the competition law recommendations, there are three areas which may be worth highlighting. One are changes to the merger review process. The second are changes and important simplifications to the cartel laws and the laws concerning the joint venture defense to cartel conduct. And finally, and perhaps most controversially, changes to the misuse of market power provisions. In terms of mergers, there is a formal merger review process currently in the Act. However, it's very prescriptive, and as a result, it's never been used. The panel's recommendations include making the formal merger review process a much friendlier type of system. For example, there will be no prescriptive information requirements. There will continue to be a merits review by the Competition Tribunal, and there will be strict time limits on a decision by the ACCC in the first instance and a decision by the Competition Tribunal if there's a review. That could make formal merger review a genuine option for Australian businesses who are planning to merge. In terms of joint ventures are clearly an important element of the Australian economy, and it's important that joint ventures be able to recognize when they're engaging in legitimate joint venture conduct and when they are at risk of being accused of being engaged in a cartel. The current joint venture defense is incredibly prescriptive, incredibly detailed, and very difficult to understand, and also narrow in its scope. The panel, helpfully, is recommending both the simplification of the law and making it not so narrow. It's obviously of interest to the economy that people engaged in joint ventures are out doing their business and not sitting in their lawyer's office making sure that their conduct is meeting certain overly prescriptive rules. In terms of the misuse of market power provisions, this has been an incredibly controversial area. In essence, the law at the moment focuses on a corporation's purpose in engaging in particular conduct. The panel is recommending the introduction of an effects test to the misuse of market power provisions. This is a substantial change to the law. The panel acknowledges that there will be a period of uncertainty. In my view, it significantly underestimates the uncertainty that this change will bring about if it comes to pass, and I think it also underestimates the possibility that corporations will no longer engage in legitimate, if aggressive, competitive activity on the basis they're concerned about being accused of abusing or misusing market power under a revised provision.
So Patrick, what are the next steps?
Minister Bilson, when he made public the Harper Review report, said there will be an 8-week period of consultation. I expect there'll be some furious consultation during that period, and he did say that the government's intention would be to have a response to the report available by the end of this year.
Patrick, thanks for joining us and taking us through some of the recommendations.
You're welcome.